For the purpose of legislative intent to the proponent of the bill.
Please proceed, sir.
Thank you, Mr. Speaker. Specifically, in Senate Amendment C, which became part of the bill, we have this exception here that if a religious organization provides certain services, that the act doesn't affect the manner in which they provide the services. And my question is, what if one of those organizations does receive state or federal funding? How would those institutions be affected? Through you, Mr. Speaker.
Representative Lawler.
Thank you, Mr. Speaker. I think I answered this question earlier, but I'll repeat it. I think under the Kerrigan decision, the state cannot discriminate against same-sex couples. So if it's a private entity acting on behalf of the state, I think that the Kerrigan decision would probably apply under those circumstances. Through you, Mr. Speaker.
Representative Candelora.
Thank you, Mr. Speaker. And just through you, Mr. Speaker, as a hypothetical, if I believe the state provides transportation services for parochial schools, I'm not sure how that money flows. If a private school is providing in the course of their education social services, if, for instance, my wife taught at a Catholic school where they provided toiletries and some other family services for students, if they're receiving transportation funds, whether it be through a local municipality, but they are state dollars, would they be potentially in violation of this act or would be precluded from receiving those state funds? Through you, Mr. Speaker.
Representative Lawler.
Thank you, Mr. Speaker. There's a broad exemption for religious schools under the bill, so they would be exempt. Religious schools are exempt.
Representative Candelora.
Thank you, Mr. Speaker. Just through you, Mr. Speaker, I guess what if then, for instance, it's a foster care agency then, as a hypothetical, we would necessarily be precluding them from receiving state or federal funds under this exception. Am I correct through you, Mr. Speaker?
Representative Lawler.
Thank you, Mr. Speaker. No, they would not be precluded from receiving funds.
Representative Candelora.
And I guess why would that be in a hypothetical if a foster care agency was receiving state funds, they would be precluded from discriminating against same-sex couples in order to be able to receive the state funding, as I read the exemption. Am I correct through you, Mr. Speaker?
Representative Lawler.
Thank you, Mr. Speaker. Well, the question was about receiving state funds. Under the Kerrigan decision, the state is precluded. It's considered to be unconstitutional to discriminate against same-sex couples when it comes to marriage. So if it's a private agency acting in the state's stead, if they're running a state program, then I think the decision would apply to them as well. So they can do whatever they want except discriminate if they're acting on behalf of the state.
Representative Candelora.
Thank you, Mr. Speaker, and I appreciate those answers. And I asked them, and I guess it points to an issue that I do have with the way these exemptions are framed, because the Kerrigan decision dealt with state action, and what this exemption is doing is actually setting public policy in that we are saying as a state today that foster care agencies, social service providers, adoption agencies that may have a religious component, may be provided by a religious organization, will be precluded from state or federal funds. And I don't believe the Kerrigan decision had gone that far. And I understand that this exemption was written as a compromise for the purposes of allowing the Catholic Church to provide their adoption services. But I'm concerned that we are now setting a policy of excluding any religious organization from state or federal funding. It's fairly broadly written. It's not necessarily direct funds that are flowing through. There may be a case where these agencies are receiving the funds indirectly. And at the very least, I think that this exception needs to be fleshed out more. I'm disappointed in the manner in which we're voting on this legislation tonight. This is an extremely important issue. We've all had hundreds of phone calls from individuals across the state of Connecticut, and I have to say, I will be going back to my district a bit embarrassed to tell them that we took up this bill with about 15 minutes of notice, and we're trying to craft a piece of legislation to address the Supreme Court decision without any prior opportunity to flush out the details. Thank you, Mr. Speaker.